Good afternoon, students. I'm back with our topic Intellectual Property Right IPR Part 2. So, today we are going to discuss types of IPR and the different type of IPR in detail. So, let's start today's topic IPR Part 2. In our previous slides, in our previous presentation, we have already discussed the types of IPR. Today we are going to revise it. Types of IPR. Students, intellectual property rights are divided broadly on two types, industrial rights and second one is copyrights and related rights. Under industrial rights comes trademarks, patents, trade secret, geographical indication. Copyright and related rights are of single type. There is no subdivision of this type. In this regard, first comes the patent. We have very often we have listened that following scientist has received a patent. हमने ऐसा हमेशा सुना है कि और फार्मास्यूटिकल फील्ड में तो ये बहुत ही कॉमन सी चीज है दैट द पर्टिकुलर साइंटिस्ट और रिसर्चर हैज गेन्ड अ पेटेंट ओवर हर इनोवेशन और his or her innovation. So what is patent? The term we are very much familiar and आप में से कई लोगों को तो शायद ये अच्छे से पता भी होगा कि पेटेंट क्या है, तो हम एक बार रिवाइज कर लेते हैं. पेटेंट इज अ ग्रांटेड फॉर एन इन्वेंशन which is new product or process that meets condition of novelty, non-obviousness and industrial use. Students, here three things have been mentioned, that is novelty, non-obviousness and industrial use. These three are actually the basic of patent. जो भी हम नई चीज खोज कर रहे हैं या हमने खोजी है, इनोवेटिव कोई भी हमने फॉर्मुलेशन बनाया है, इन केस ऑफ फार्मास्यूटिकल साइंसेस इफ यू आर टॉकिंग अबाउट, अगर हमने कोई फॉर्मुलेशन बनाया है, इफ यू हैव मेड एनी टाइप ऑफ इनफैक्ट ड्रग डिलीवरी सिस्टम भी अगर हमने कोई बनाया है, तो पहला तो उसमें सबसे इंपॉर्टेंट चीज है कि वो नया होना चाहिए, नोवेल्टी होनी चाहिए उसके अंदर में. दूसरा, वो नॉन ऑब्वियस होना चाहिए, है ना. और तीसरा, इट शुड हैव एन इंडस्ट्रियल यूज. अदर देन दिस, two more things are there, that it should be economic and it should not harm any creature, any living thing, anything on this earth. So if a patent or an innovation, whatever a scientist have done, if that innovation is novel, non obvious, have industrial application, it is economic, and if it is safe, then a patent is granted to that particular innovation. और यहाँ एक चीज जो मैं आपको बताना चाहूंगी वो ये है कि मिनिस्ट्री जो आईपीआर को गवर्न करती है वो है डिपार्टमेंट ऑफ इंडस्ट्रियल पॉलिसी एंड प्रमोशन और मिनिस्ट्री ऑफ कॉमर्स एंड इंडस्ट्री. और पेटेंट जो है वो इंडियन पेटेंट एक्ट 1970 के अंदर में आता है, जो कि 2005 में एक बार अमेंड हो चुका है. Students, now comes trademark. A trademark can be a device, brand, or a heading or a label, ticket name, packaging, sign, word, letter, number, drawing, picture, color or combination of colors, shape, good, signature or combination thereof. A trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one undertaking from those of others. Undertaking shall be capable of constituting a trademark. Trademark is very important when an industry is associated because it सिग्निफाइज द इंडस्ट्री. हम एक ट्रेडमार्क देख करके उसकी इंडस्ट्री को हम आराम से क्या कर सकते हैं, पहचान सकते हैं. इट इज़ वेरी मच इम्पॉर्टेंट. अब ये आपका लेबल भी हो सकता है, एक कोई डिवाइस भी हो सकता है, कोई ब्रांड भी हो सकता है. वी ऑल नो गूसी, we all know Titan, we all know there are different type of brands, we all know Coca-Cola, we all know Pepsi. All these are trademarks. Now ministry administrating the IPR, same from the previous patent and design, that is industrial policy and promotion, and Ministry of Commerce and Industry. The concerned act with this trademark is the Trademark Act 1999, which was lastly amendment had been done in this act is in 2010. Now comes geographical indication. In our very first presentation we have already discussed geographical indication in detail, so I'm not going to discuss here also. But geographical indication identifies agriculture or natural or manufactured good as originating or manufactured in the territory of a country or region or locality in that country, where a given quality, reputation or other characteristic of such good is essentially attributable to its geographical origin, and in case where such goods are manufactured, good one of the activities of either. For example, जैसे हम बोलते हैं geographical indication में आती है बनारस की साड़ी और आपका दार्जिलिंग की चाय, ये सारी जो चीज़ें हैं, बासमती राइस है ना, ये सारी जो चीज़ें हैं ये जोग्राफिकल इंडिकेशन को बताती हैं कि कोई भी जो चीज़ है वो कहाँ निर्मित हुई है, कहाँ, कौन से रीजन को, कौन से टेरिटरी को, कौन सी लोकेलिटी को बिलोंग करती है. और ना सिर्फ ये बताती है बल्कि वहाँ के जोग्राफिकल कंडीशंस जो हैं वो उस क्वालिटी की चीज़ों को उगाने में समर्थ हैं, ये भी हमें उस चीज़ से पता चलता है. अगेन मिनिस्ट्री एडमिनिस्ट्रेटिंग इज सेम, डिपार्टमेंट ऑफ इंडस्ट्रियल पॉलिसी एंड प्रमोशन एंड मिनिस्ट्री ऑफ कॉमर्स एंड इंडस्ट्री. The concerned IP Act is the Geographical Indication of Goods Registration and Protection Act 1999. Now students, when we come on copyright, when we start discussing about copyright, so copyright, as we have already discussed in our previous presentation, that copyright is received on any kind of artistic or this type of work. So what are the categories of project work that are protected under copyright? Are text based work, whether it is an article or a story or a theme or something like that. If it is artistic work, if it is film, if it is music, if it is broadcast, if it is sound recordings, if it is typographic words, or if it is dramatic works, all these things that is related to the intellect of a human being comes under Copyright Act. Another important right is plant variety protection right. Protection granted for plant varieties, the right of farmers and plant breeders, and to encourage the development of new varieties of plants. This is the motto of this Plant Variety Protection Act. The ministry that is administrating IPR here is Department of Agriculture and Cooperation and Ministry of Agriculture. And the protection of plant varieties and farmer rights, also known as PPV and FR Act, it is first introduced in 2001. So a student here, this is an important thing that is different from other acts, so you should note down this Plant Variety Protection Act. Students, when we talk about intellectual property right, we have understand the scenario in our country. Now what about IPA in worldwide? So there is a TRIPS agreement. The TRIPS agreement It came into existence on 1st January 1995 and to the date is the most comprehensive multilateral agreement on intellectual property. By the help of TRIPS agreement, one researcher or a scientist or anyone who has created something new or novel, and if you want to get a patent or if you want to get it copyrighted under TRIPS agreement, he has the right to protect its novel innovation worldwide. When we are talking about TRIPS, we must know that India, our country, is also a signatory of TRIPS in the Uruguay Round Agreement in 1995. It is now bound to amend her existing law in order to make it TRIPS compliant. Okay, the government has initiated action to bring the request changes, and in the last few years, India has enacted fully TRIPS compliant Trademark Act, Copyright Act, Design Registration Act, Geographical Indication Act, and Protection of Layout for Integrated Circuit Act. A novel Plant Varieties Protection and Farmer Right Act 2001 and the Biodiversity Act 2002 are also in place. The Biodiversity Act is also very much important. This I want to specifically specify for those who want to do or those who are doing research on herbal drugs. If you have, we generally what do we go for a plant search and we take out the extraction if we found that yeah very less work has been done and simply we used to authenticate it, and from wherever we are authenticating it from a body central body, then we go for our research work. But if we found something innovative in that research work and if we want to file a patent, means if you got an isolated product that is novel, that is having very good activity, if it is having for example anti-cancer activity or something like that, and you want to get it registered, the first and foremost step that you have to done when you are doing research work over plant or plant related something compounds, then you must get registered for Biodiversity Act 2002, because unless and until you have registered under Biodiversity Act, you are not able to file a patent or your patent will not progress. So it is an important act that all the researchers who are working in the area of pharmaceutics or who are working in the area of herbal formulation or pharmacognosy or phytochemistry, they should be well aware of the Biodiversity Act 2002. We have discussed about IPR, but we have not discussed about IPR infringement. IPR infringement is a very big issue if it is related to patent, if it is related to geographical indication or a trademark or a copyright. Infringement means जिसे हम कह सकते हैं चोरी. ठीक है, तो आईपीआर की चोरी या आपकी बौद्धिक संपदा की चोरी भी होती है और लोग उसे गलत तरीके से प्रोड्यूस भी करते हैं. तो हाउ वी कैन नो व्हाट इज आईपीआर इन्फ्रिंजमेंट और हम उससे कैसे बच सकते हैं, चलिए अब हम इसके बारे में डिस्कस करते हैं. Students, infringement is a legal term for an act that means breaking a law. IPR rights are infringed when a product, creation, or invention protected by IP laws are exploited, copied, or otherwise used without having the proper authorization, permission, or alliance from the person who owns those rights or their representative. For example, infringement जो है वो एक तरीके का टर्म है, लीगल टर्म है, जिसका मतलब होता है तोड़ना. अगर हम किसी ऐसे व्यक्ति के अधिकारों का शोषण करते हैं, दमन करते हैं या उससे पूछे बिना उसकी द्वारा इन्वेंट की हुई कोई भी चीज का इस्तेमाल करते हैं विदाउट asking, without proper authorization, without permission, and without allowance, then it comes under the category of infringement. और एप्पल और सैमसंग का जो विवाद था वो infringement की कैटेगरी में आता है. It can range from using technology protected by a patent to selling counterfeited मेडिसिन, सॉफ्टवेयर और कॉपिंग ऑफ फिल्म, मेकिंग इट अवेलेबल ऑनलाइन, जिसको हम कभी कभी प्लेगराइज भी कहते हैं. गलत तरीके की मूवी को हम कॉपी कर लेते हैं और कॉपी करने के बाद हम उसको इंटरनेट पर बेचते हैं, जो कि कॉपीराइट के तहत एक अपराध है. इन्फ्रिंजमेंट जो है वो वॉयलेशन है इंटेलेक्चुअल प्रॉपर्टी राइट का. There are several types of intellectual property rights such as copyright, patent and trademark. Therefore, an intellectual property infringement may be of that types such as copyright infringement, patent infringement and trademark infringement. Copyright infringement. Copyright owners generally have the right to authorize or prohibit any of the following things in relation to their work. क्या क्या उन्होंने मना किया है कॉपीराइट धारकों ने, वो है कॉपिंग द वर्क इन एनी वे, फॉर एग्जाम्पल फोटो कॉपिंग, रिप्रोड्यूसिंग अ प्रिंटेड पेज बाय हैंड राइटिंग, टाइपिंग और स्कैनिंग इनटू अ कंप्यूटर और मेकिंग अ कॉपी ऑफ रिकॉर्डेड म्यूजिक. दूसरा है इशूइंग कॉपीज ऑफ द वर्क टू द पब्लिक. थर्ड इज रेंटिंग और लेंडिंग द कॉपीज ऑफ द वर्क टू द पब्लिक. Fourth is performing, showing or playing the work in public, or broadcasting the work or other communication to the public by electronic transmission. If under this category, if you falls, then it comes under copyright infringement. You cannot reproduce or you cannot copy, you cannot photocopy it, you cannot handwritten it, you cannot type it, not scan it, you cannot do anything of that particular invention without the permission of that person who has invented the or who has copyrighted it. Patent infringement. Infringing a patent means manufacturing, using, selling or importing a patented product or process without the patent owner's permission. The owner of a patent can take legal action against the person and claim damages if suspect has infringed their patent. Now, IP infringement is a criminal IP offense and it is known as counterfeiting or piracy. Counterfeiting can be defined as the manufacture, importation, distribution and sale of product which falsely carry the trademark of a genuine brand without permission and for gain or loss to another. And piracy, which includes copying, distribution, importation, etc. of infringing work, does not always require direct profit from seller or wider, and indirect benefit may be enough along with inflicting financial loss on to the right holders. So these are the two words that you must remember, that is counterfeiting and piracy. We often heard about piracy but we have not listened about counterfeiting, so you must remember these two terminologies. Now students, a question may come in your mind that how we can avoid infringing. Infringing can be avoided. Before filing a patent, we should have a complete information on the database of the patent, so that we must know what is going on in the patent database, what words or what the thing we should be aware while filing the patent. And the most important thing, we should take a professional advice from a patent attorney, trademark attorney or a solicitor for avoiding any kind of infringement. Now, coexisting agreement. A coexistence agreement is a legal agreement whereby two parties agree to trade in the same or similar market using an identical or similar trademark. The agreement is drawn up between parties and set the parameter for each to use their trademark without the fear of infringement or legal action from the others. The coexistence agreement set the terms and conditions the parties have agreed to allow each other to undertake their respective business activities. So by coexistence agreement, different industries which are producing same kind of drug, they can have similar kind of trademark also, but slightly different from each other. They can also coexist in the market for mutual benefit. So students, here we come to an end of our presentation. In this presentation, we have discussed about the types of IPR, patents, copyrights, trademarks, geographical indication in their infringement, how we can recover from infringement, how we can avoid infringement, what is coexistence agreement. So I think that all these terminologies and the concept will be helpful in your studies to develop a good and novel concept for a better understanding. Revise whatever we have studied. Stay at home, stay safe and study well. We will be back with our next presentation on drug regulatory affairs. Thank you.